very warm welcome to Landmark Case Analysis, which is presented to you by LawSikho. This is Ankita Parida here. Now let's begin with our landmark case, Chiranjit Lal Chowdhuri versus the Union of India and others. This is a landmark judgment given by the Honorable Supreme Court of India on 4th December 1950 by a 5-judge bench. Now let's understand the background of this case. There was a company in Solapur known as the Solapur Spinning and Weaving Company Limited. This company was engaged in the production of an essential commodity and also it had huge number of employees. However, this company was not running well in the post-independence era during 1950s and huge number of employees had been left unemployed or were not paid salaries. At that point of time, the government of India was trying to overtake the Sikh industries and was trying to nationalize them so as to secure the employees and give them financial support and indirectly support the economy. So, in this case, the Governor General of India found that it is in the hands of mismanagement and a situation has arisen in the affairs of the company which has affected the production of an essential commodity and has caused serious unemployment among certain section of the community. Therefore, he promulgated an ordinance which was later on replaced by an act of parliament, and this act was known as the Solapur Spinning and Weaving Company Emergency Provisions Act 1950. Based on this act, the directors of the company, who were the core management of the company, were dismissed and the government was authorized to appoint new directors and the rights of the shareholders of the company were curtailed. So these were the necessary steps taken in order to redress the Sikh industry. Also, the government modified the Indian Companies Act so as to bring it in accordance with the provision of the ordinance, and based on that, new directors were appointed by the government. So, based on these events, a petition was filed by Chiranjit Lal, who was the shareholder of the company, and he made an application under Article 32 of the Constitution, stating that this impugned act was in violation of his fundamental rights under Article 19, 31, and 14 of the Constitution, and therefore it must be declared void under Article 13 of the Constitution. So, based on this, the issue of law involved in this case are whether the act is in contravention with Article 14, Article 19 subclause 1F, and Article 31 of the Constitution. Secondly, whether the impugned legislation amount to acquisition of taking possession of the private property within the meaning of Article 31 of the Constitution of India. And thirdly, whether the property belongs to shareholders or the company. Now let's have a look at the judgment by the court. The Supreme Court held that a company and a shareholder are two separate entities and they are distinguished by intelligible differentia. Therefore, a shareholder cannot seek its right with respect to right to property and cannot claim that the acquisition of any property of the company has infringed his fundamental rights, as a share is not considered as a property under the ambit of Article 31. Therefore, the Supreme Court held that this impugned act does not infringe on any fundamental right guaranteed by Article 31 of the Constitution, and it held that the act has judiciously treated the mill as a separate class. Therefore, if the act has any way authorized of taking possession of the property of the company, then the petitioner, who is the shareholder, is not entitled to any relief on that score of Article 32. Secondly, the Supreme Court also held that this act does not infringe upon the fundamental right of Article 19 because it does not impose any restriction on the petitioner, who is a shareholder, to acquire, hold or dispose his shares, and therefore putting restriction on exercising the right does not violate the fundamental right under Article 19, Subclause 1F of the Constitution, and these restrictions fall under reasonable restriction imposed in the interest of public under Article 19 of the Constitution. The Supreme Court, however, held that this act violates Article 14 as alleged by the petitioner, as it denies the shareholders of a particular company to exercise their rights, and it does not apply to all the companies of the land. Therefore, it violates the fundamental rights under Article 14 of the Constitution, and the Act is discriminatory in character. Lastly and most importantly, the Supreme Court held that the fundamental rights guaranteed by the Constitution are not merely available only to the citizens of the country but also are available to the corporate bodies as well. And therefore, any company which is incorporated in India can come to the Supreme Court for the enforcement of their fundamental rights, and similarly, the individual shareholders also hold the right to move up to the Supreme Court to enforce their fundamental rights separately. However, a company or a corporation being a different entity from the shareholder, thus the shareholder cannot complain about the ground that the rights of the company under Article 19 and 31 is infringed. So this was all about this case. Thank you.